Everybody go grab your real rum. Support we at least them on number one. Shine bright like Jamaican sun.
Where am I the winning spirit?
We rum.
The winning spirit.
We rum.
Jamaican spirit. Where am I the winning spirit?
Must be 18 years old to drink responsibly.
Informative, educational, insightful. Let's talk justice. Tackling topics like constitutional rights and reform, domestic violence, and rights issues that affect you. Let's talk justice every Monday starting June 24 from 1 to 2 p.m. on Nationwide 90 FM. Call in, share your thoughts, be empowered, know your rights, and let's talk justice, ensuring access to justice for all, courtesy of Jamaicans for Justice.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty.
Welcome to another episode of Let's Talk Justice. My name is Michael Jackson, Executive Director of JFJ.
I'm Jade Williams, Policy and Advocacy Specialist at JFJ.
Jade is not 100%, so bear with her this week as she recovers. But thank you so much for joining our weekly program. We especially thank those, you could have been anywhere else, but you're here talking justice with us. So those on the Nationwide YouTube platform, those who are watching via JFJ's YouTube platform, and of course those who are very traditional, listening to the regular radio. We appreciate your audience and again for staying tuned. Now, last week, the news item of the week is that Kensington case, the Virgo family, Dale and Shireen Virgo, the mother of a child who was 5 years old at the time, who was subjected to an unfortunate occurrence as a black child in a largely homogeneous society where most of us are black people, right? So that case, we got the court ruling last week, and we're going to be talking a little bit more about that for the first half of the program. We're going to be joined by the children's advocate, Diane Gordon Harrison, and we're also going to be joined by attorney at law out of Belize, Leslie Mendez.
Yes.
Right?
Yes.
So the week that was, very quickly, the case will be the week that was substantively so, and I have a little bit of what you would call it, follow-up to last week when we had focused on the Integrity Commission, but we will put that to the second half of the program. But before we get into it, to our listeners, we saw where our friend and colleague, Executive Director of the Jamaica Environment Trust, Dr. Theresa Rodriguez Moody, she was on the front page of the Gleaner, nicely being celebrated for her advocacy in environmental rights and climate justice. Well deserved. She joined JET in 2021 around the same time that I joined JFJ, and I can tell you we have a little bit of a network within civil society, and when we must celebrate the other, we do so. Well deserved advocate and the front page coverage that she got from the Jamaica Gleaner. All right?
Yes.
So your trivia, Jade?
Well, I have two things. I do have a right of the day as well. As well as the trivia. So we'll start with the right of the day, which for today is coming from our Constitution, and it is section 13.3h, which speaks to the right to equitable and humane treatment by any public authority in the exercise of any function. And this right is there to ensure that individuals are treated justly and humanely without discrimination or bias. And we'll be talking a little bit about that right today as we discuss the findings from the Kensington case. We also have a trivia question which asks, where in section 13 of the Constitution do you find the right to freedom of expression, and which is also a poignant right for this case. So we're looking forward to seeing your responses. You can send a WhatsApp to 2397583. You can respond in the Nationwide live chat, but if you do get your answer correct, you send a WhatsApp.
All right, so let's get straight into it.
Yes.
Now, if you remember in 2018, the Virgo family, Dale and Shireen Virgo, they brought a constitutional matter against the board of the Kensington Primary School and several government entities, including the office of the Ministry of Education. And the parents had asserted that the rights of their child, and to protect the child's privacy, we will call the child ZVZV, however you pronounce that letter, to freedom of expression, the right to a public institution, educational institution, freedom of religion, right to a private and family life, and equitable treatment by a public authority. Those are the rights that the family had asserted were breached by the Kensington Primary School, that had refused the child being admitted to school unless the dreadlocks were removed. Unfortunately, the school had justified its decision on the basis that they had past experiences with hygienic concerns and prior incidents involving other children. Those were the pushback that the school had provided at the time as the basis for saying that what we're doing is quite in keeping and with the rules of the school. All right?
Now, that original case was concluded in 2020 when the full court of the Supreme Court found against the parents, so in favor of the school and those that were brought the action against, based on the interpretation of several of the rights that were challenged. So the court went through a whole interpretation exercise, and we're going to discuss some of that today. But based on that interpretation exercise, it found that none of the rights were breached. And in response to that lower court ruling, Jamaicans for Justice would have been vocally highlighting the deficiencies in the Education Act and the education regulations, stating that they were inadequate in protecting children from arbitrary and discriminatory restrictions that are being imposed by schools.
No, the family had appealed the ruling at the Court of Appeal, and that judgment was handed down last week on July 15th. And the judgment had indicated that they upheld some components of the Supreme Court's ruling. For example, the judgment clearly indicated that the child's freedom of religion, right to education, right to private and family life, those were not breached. But the two substantive rights that the Court of Appeal would have overturned based on the decision of the Supreme Court is the right to freedom of expression and equitable and humane treatment by a public authority. So when we return from the break, we're going to be talking a little bit more about the case and breaking it down with you, and we're going to be having the children's advocate and an attorney from Belize who had worked on the case that focused on freedom of expression.
Calling all fisher folk and aquaculture farmers. Now you can get your license quick. Log on to iRefins and check out the thing. Use your smartphone and click. Register, pay and get your license. Sign up for iRefins, cause real fishermen have them licensing of them on. Go to irefins.nfa.gov.jm or contact the National Fisheries Authority. iRefins is a joint project of the NFA and the Transformation Implementation Unit.
The Ministry of Health and Wellness is now accepting applications for the Dr. Barry Wint Memorial Scholarship. Jamaican citizens pursuing a first degree, master's or PhD in any health-related field, including medical social work, human resources for health, nursing, dentistry, health economics, or any other, can qualify for up to $1 million per year for 5 years to complete their studies. Visit www.moh.gov.jm/scholarship for more details and to submit your application. Deadline date is Wednesday, July 31, 2024. We look forward to seeing your application.
Ready, set, go!
Where am I, the winning spirit? The winning spirit. Jamaican spirit. Where am I, the winning spirit?
Time for unite as one. Everybody go grab your rear rum. Support we at least them on number one. Shine bright like Jamaican sun.
Where am I, the winning spirit? The winning spirit. Jamaican spirit. Where am I, the winning spirit?
Must be 18 years old to drink responsibly.
Pamper your senses at Bodyscape's newest spa and grooming club, located at 34 Mannings Hill Road in Kingston. For the month of July, celebrate 5 serene years with them. Take advantage of their specials on facials, massages, manicures, and waxing services as you treat yourself and loved ones to a wellness escape. Call 876-627-9454 or message them on Instagram at BodyscapeJA. Conditions apply. Experience a world of pampering at Bodyscape, now in Kingston, Jamaica.
Welcome back to Let's Talk Justice. We are to be discussing today the decision coming out of the Court of Appeal decision coming out of that Kensington primary case. And we are joined by Attorney at Law Leslie Mendez, and we are also joined by Children's Advocate Mrs. Diane Gordon Harrison. Thank you for joining us.
Good afternoon to you both.
Good afternoon, everyone. Thanks for having me.
Thank you. Mrs. Gordon Harrison, our children's advocate. Let's start with you, because you're also listed as an intervener in the document here, in the court proceedings. So what is your immediate reaction to the judgment that was handed down last week?
Well, I think it's, first of all, a very what I would like to call a groundbreaking decision. It's a case that really looked at an issue that comes up ever so often in various school environments and for a number of different reasons. Not necessarily dreadlocks, but we have had this as a recurrent discussion in a number of spaces. So in this particular case, private counsel were retained by the Virgos to pursue the matter on their behalf, but given the mandate of the Office of the Children's Advocate, and in the broad terms of the legislation, it says we are to, protect and enhance the interests of children and also the preservation of rights. We thought that such a fundamental case proceeding to court really called on us to be interveners, interested parties, and to be there to make submissions as deemed appropriate, and also to consult with counsel who were advancing the arguments on behalf of the Virgos. And so that is why we are there listed as intervener, and certainly at both levels, both at the Supreme Court level and the Court of Appeal, we had to make submissions. And so we find that it's a very, as I said before, groundbreaking set of circumstances that the Court of Appeal has pronounced upon, and really has ushered in now a period or an era where I think a lot of school administrations may have to have very comprehensive discussions as to how they move forward, how they chart the course forward in terms of striking that balance for having uniformity and good order as they determine it in their school, whatever those parameters are, vis-a-vis the opinion of the court and the decision of the court that the freedom of expression is in fact sacrosanct, and also that there is this fairness that public institutions ought to have at the forefront of their minds when interfacing with persons. And this judgment speaks to children, but I dare say it's going to have, perhaps even more far-reaching effects based on the precedent that it has now established.
Yeah, thank you. Before we start breaking down some elements of that judgment, Ms. Mendez, freedom of expression, a lot of people tend to just limit it to how you express your opinion in terms of an oral expression or perhaps even in writing. But we're seeing where freedom of expression should be broadly looked at in terms of even the physical manifestation, how you dress and so on. And I know you have an experience with with a matter that you dealt with, I believe, in 2019 in Belize. So if you could just quickly summarize that matter for the listeners and perhaps give your thought on this particular case and what freedom of expression means so the listeners can appreciate that broader concept of that constitutional right as is provided for.
Yes, sure. In terms of the right to freedom of expression and the different ways in which it can manifest, right? I think, at least in the Caribbean and in Belize, certainly, we're very much influenced by the McEwan case delivered by the Caribbean Court of Justice. That was the first time that our highest court would have looked at freedom of expression beyond words, beyond specific opinions, and also beyond the context of the more traditional ways in which we think of the right to freedom of expression, which is the press, for instance. So in that case, the court looked at freedom of expression in the context of how you dress, where there was a challenge to a prohibition against cross-dressing, for instance, and there was the first time that we saw freedom of expression being protected, being used to protect your physical appearance and your choices in how you dress.
Just to clarify for the listeners, Ms. Mendez, that was the case where a group of transgender women had dressed in female clothing, and I think they were detained by police officers in Guyana.
Indeed, and there was a law in Guyana that prohibited that, meaning that criminalized the act of cross-dressing.
Yes.
And so the court looked at it and struck down that specific law. One of the bases of it was the right to freedom of expression. In Belize, it's very much a comparable case when it comes to the Virgo case. And in fact, I think both cases were kind of running a little parallel to each other, if I'm not mistaken, because it was around the same time that the case came before the court. And in that case, it was similar. The challenge was to rule or to an order against the wearing of locks, but this time in the context of the Belize Police Department. The matter was brought on by two female officers of African descent who were ordered by their superiors to remove their locks. Else they would face disciplinary proceedings. We argued the case on the basis of the right to equal protection of the law, the right to not be subjected to discrimination on the basis of race, the right to freedom of conscience, and as well as the right to freedom of expression. In short, I can say that the argument for the officers was that the hairstyle formed part of not only their religious beliefs or their conscience beliefs, but also their racial and cultural identity. So they argued that they expressed their views, they celebrated their cultural identity through the act of wearing their locks, their hair in locks. It was a symbol of resistance to Eurocentric standards of beauty and professionalism. Mm-hmm. And so that is the message, that was the content of the hairstyle that they were signaling out to the world. And in that sense, we saw that locks as a locus of where you see expression, conscience, race, political belief, as well as religion sort of interacting in the same space. The department argued that rules are rules, and they really focus on the interests of the department as the police department, as an arm of the government that seeks to enforce the law, the need for officers to follow rules, as well as the need for uniformity. But the court in that case said, although the court recognized the interest of uniformity and of discipline and of having rules, certainly, the court emphasized that that was a legitimate claim. The court also said that uniformity, however, must contemplate and accept that hair and people, although in this case hair comes in different lengths and in different textures. And so the view of uniformity and the way in which we apply the rules must also accommodate. And so the court found that in this case, the directive, the order that they removed their hair, was in breach of the right to freedom of expression, certainly. as well as the right not to be subjected to discriminatory treatment on the basis of race. One thing that I didn't really, that was sort of different now that I was looking at the Virgo case from the case in Belize, was that in the case in Belize, the history of Belize and the cultural and the political context that we come from was definitely at the center of it. The court said that here is undoubtedly intricately linked to our history and our identity, considering the history of slavery in Belize and the systemic discrimination of one of our indigenous groups that are African, that are Afro-descendants, which is the Garifuna peoples of Belize. And so the court really emphasized the need then to protect this form of expression, to protect this form of cultural expression as well in this context. So there was an emphasis on this discriminatory aspect of the prohibition against locks.
Thank you so much. Mrs. Gordon Harrison, I've listened to Ms. Mendez outlined the freedom of expression and how her particular case was viewed by the courts in Belize. And even reading this particular judgment, what jumped out at us here is this concept of self-identity and the fact that the child's dreadlocked hair was a representation of the family's lifestyle rather than the freedom of religion. So I think the question here is, what are the broader implications for our children in public institution wherein it's not a religious belief issue, because the courts said that, given the timing when the family had raised the freedom of religion, it could not be contemplated. But this matter of self-identity, the matter of physical manifestation of lifestyle, what are the implications for other children who just want to wear their natural afro, for example?
Right. So, Mikhail, you have hit smack on the nail, I think, in terms of where we have to start looking. As I said in my opening remarks, what this now means is that because we have squarely had a clear adjudication on the issue of self-expression, not intertwined in any other thing. As you said, it's not that, as we've had in the past, persons who are part of the Rastafarian faith can, by virtue of religious reasons, wear their locks. Persons who are, for example, Muslims are allowed to wear a head covering to school and so on. This decision takes us out of the realm of having a conditional kind of acceptance. And so what it means is that I think various school boards and administration of public institutions now have to consider very carefully what are our guidelines and our rules stipulating, because we don't want to transgress the particular dictates of the court as regards to the preservation of self-expression. You speak about, for example, persons wearing an afro. Again, I know some schools have moved on and that is now particularly acceptable, but then there are other schools who have not. And so the question is, what is going to be the new order of the day for both girls and boys? Because again, I know that there are problematic issues on the male side in terms of how hairstyles are worn, what is allowed, what is not. I remember some years ago we had a video surfacing of a male school teacher holding down a child and shaving his head because it did not fall on all fours with what he considered appropriate for the school context. And so we need to be looking at, or our schools rather, need to be looking at what's included in their rules, what's included in additional guidelines that have come up outside of the standardized school rules, and what generally is their policy, and really have some discussions and training perhaps, or sensitization of, deans of discipline and guidance counselors and so on, to ensure that everyone is operating on the same page, keeping in the forefront of their minds exactly what this decision is saying, because it really has ushered in a new day, where, as I said, there are no conditionalities anymore, but freedom of expression is being looked at on its own legs, and we have to ensure that, it doesn't create a problematic issue, while at the same time, Mikhail, ensuring that the respect for rules and the fact that it's not a free for all in schools has to be weighed on the other side of the pendulum as well.
Yes. Thank you. I'm going to ask you, Mrs. Gordon Harrison, to stay with us on the other side of the break, but we're 2 minutes away. So I just want to leave Miss Mendez with the last word in terms of what her recommendations would be to Jamaican schools and understanding freedom of expression in a broader context and not limiting it to, any tie to religion and so on. What would be your recommendation for going forward?
Well, I would echo the sentiments of Mrs. Harris in that I do think that we would need to undertake, again, a comprehensive review of some of the rules, assess how they impinge on this more broader interpretation of freedom of expression, assess very clearly what really, especially when we're talking about some of the prohibitions that are included in some of these rules, I think a consideration of why it is that we are prohibiting.
Milan, call again.
And hello?
Yes, we're hearing.
Why is it that we are prohibiting these? Why is it that we are instituting these prohibitions and then consider collectively whether there aren't any alternatives that could be contemplated to address whatever concern the rule is intended to deal with? I think that was definitely something that came out from the case.
Yes.
The need to always bear in mind proportionality, the need to always bear in mind, contemplate other ways as opposed to very drastic measures such as excluding a child from school.
Yes. Thank you so much, Ms. Mendez. We really do appreciate your time with us. We're going to And again, you can take your leave because I know you indicated you have something else that you must attend to. We're asking the children's advocate just to stay with us a little bit more because I want us to probe some of the concerns of what we did not win in that Court of Appeal ruling and what does it mean in terms of right to education to a publicly funded institution. So we take the break.
Set, go!
Where are my winning spirit? The winning spirit. Jamaican spirit. Where are my winning spirit?
Time for unite as one. Everybody go grab your rear support we at least them are number one. Shine bright like Jamaican sun.
Where are my winning spirit? The winning spirit. Jamaican spirit. Where are my winning spirit?
Must be 18 years old to drink responsibly.
This are the national dengue free crew. Come join the fight, stop mosquito from bite you. That mean we are go clean up school, workplace, home and community too. We have a task at plan, every crevice and corner for clean of the plan. Make we get rid of dengue across the island. Let's put it on the Facebook and Instagram. Tell the whole nation say this are the national dengue free crew. Come join the fight, stop mosquito from bite you.
Mosquitoes wanted dead, not alive. A message from the Ministry of Health and Wellness.
Mrs. Gordon Harrison, you're still with us? Not hearing. All right, it seemed we lost Mrs. Gordon Harrison, but we're trying to reconnect with her. But just for our listeners, at the start of the program, we were explaining that while the Virgo, and by the way, before I even continue, let us congratulate the Virgo family on this journey of claiming their rights, because far too many of us, when things happen, we say, you know what, I just saw it go. We can't be bothered. But here was a family, they were actually with Jamaicans for Justice at the start, and they continued with Isaac Buchanan in this. At one point, you know that litigation can be costly. They set up a GoFundMe page, and that received some backlash from the public. Some people were quite willing to support, but the Virgo family, the child who is center at all of this, She's now, 11 years old, started at 5 years old, what she suffered, and 6 years later, when this judgment was handed down, she's now 11, thereabout. Isaac Buchanan, attorney at law, who persevered and secured the assistance of King's Counsel Michael Hilton. We must say congratulations to both family and legal team, because you have to have that type of tenacity to really push through with what I'm sure was an arduous journey.
Yes.
As they progressed all the way. Yeah. Mm-hmm. But when we look at the judgment that was handed down, the right to private and family life, the Supreme Court said that particular constitutional right was not breached. In other words, what you do in the privacy of your home, how it affects you as an individual within the context of what it means for your family. And the Court of Appeal upheld that decision. I'm not sure if you have any thoughts on that, Jade. I do, but I'm not sure if you have anything jumping out at you.
I think that we kind of have a unfortunate legislative trend where this right to privacy in the home is easily limited, in my opinion.
At that kind of narrow construct and what these rights mean, yeah.
Yes, I feel as though I can't say that I agree or disagree with the court.
I completely disagree.
What I will say is that I do think that there is room for a different interpretation as to the right to private. And I do think also our right to privacy in the home could be reconstructed, a little bit extended.
But in this case, it's not privacy within the home, but it's what the family and their value system would have represented, which is why I believe that life. Narrow construct, because if we had followed with that narrow meaning of what freedom of expression means, we would be limiting it to freedom of opinion and limiting within the construct of, the right to receive and disseminate information and so on, rather than that physical manifestation of who I am, my self-identity, and how I'm really looking at who I am as an individual.
I will say when the judgment just came out in 2020 and we saw that interpretation of freedom of expression, and I went on to explain it, we do our Know Your Rights sessions pretty broadly across demographics. In every demographic there was a shock that it could be so limited based on that interpretation from that case. I can't say I was displeased to see to see that.
But the other right that was challenged in the court, and let me start with the ones that were not upheld. The second one that was not upheld, freedom of religion. Section 17 of the Jamaican Constitution, and I'm going to be naming some of these sections when memory comes, old age reaching me. But when I remember, I will bring it back. So freedom of religion, the family clearly indicated that they were not of Rastafarian faith. Yes. And I have to emphasize that, because though this judgment has an implication for those who celebrate religion in different spaces and in different ways, the family expressly stated that they're not of the Rastafarian faith. And the judgment at one point had indicated that the family did not assert that as their constitutional right, because the school had said, had they asserted that as the basis for rejecting or challenging the school rule, they would have said that the child could be admitted. So I want that to be very clear. They have a particular lifestyle, and that is what the freedom of expression was challenged on. The other side, or the other constitutional right that was challenged, is the right to equitable treatment by a public authority. So in other words, when you go to any state body, any state institution, are you being treated fairly in a humane manner? And is that treatment being equitable in how you see you being treated and others? And when you look at the reasoning by school grooming policies, they are offensive, because here you are saying that, listen, if you are a black person, you're of Afro descent, for example, and you want to wear bead, you want to wear your Afro hair, you want to wear dreadlock, somehow, based on past experiences, you're going to be saying to a child, you're going to be saying to a family that your experience is that fungal infection, junjo, as you call it, lice and so on, it would have happened before. So what is different from this black child versus others? Is that rule equitable? And the courts ruled that the child's right was violated. But the other test that the judgment clearly said, was it demonstrably justified?
Yes.
And the judgment said no. They rubbished the reasoning because, again, people, you have the education's regulations, I believe, of 1961. You have different rules that schools must comply with. And the rules clearly state that if a child needs to take leave to deal with a particular outbreak, if you will, then you just have the parent take the child, you treat the child, and they bring the child back to school. There is no reason that could be justified according to the court judgment. And I'm happy because I was a little bit concerned, most of us were in the human rights field, when the Supreme Court judgment of 2020 upheld what I would call, again, an offensive policy by schools. So very, very good that that was rubbished, because, again, we have to be asking ourselves, rules, uniformity important. But we can't just say rules are rules and just blindly follow. We have to be asking ourselves, are these rules proportionate to the issue at hand? Proportionality is always key. Is this particular rule justified? What other alternative measure could be employed?
I agree, and I think even as Ms. Mendez spoke, one of the things that she said was talking about the history of Belize and why they would have had these kind of rules in the first place. And I think we also have to be self-aware as a society in that sense and consider where many of our schools are so old and the rules are just as old as the institutions. So we have to consider where we came up with these rules and whether or not the justification that we're giving them now is not a new justification.
The rules are discriminatory.
Yes.
They are backward in thinking. They are based on that colonial mindset that anything black is less than. And I think we have to call a spade when we look at these particular rules and how we've treated those who are dreadlocked, how we treat those who have different forms of expressing themselves than others. What is wrong with a child with her beautiful afro hair? A boy child with his hair maybe an inch or so high. Uniformity is important, but we have to be minded in terms of the basis for these rules to begin with.
Yes.
Yeah. The other constitutional matter that was raised, Jade and listeners, the right to education to a publicly funded institution. And the Supreme Court, as you know, again, that was one that they had said, no, that particular right was not violated.
That one I have
and the Court of Appeal upheld it. What's your opinion on that one?
I disagree with that one.
Vehemently so.
Yes.
Yeah.
I find it... I don't think it's sufficient reasoning to say that the fact that there are other institutions available is sufficient in our context. When we look at...
So in other words, the courts clearly ruled that the child's right to education was not breached because the child had an opportunity
to attend another
school.
Institution. Yeah. And I think we are ignoring so many factors in our educational system if that is the reasoning that we're going to use. Outside of just the physical access to the school, a lot of these institutions, the reason that the Virgo's case is so important is that this is not a isolated issue. It's not a single school that has this issue. It is, and Mrs. Gordon Harrison said it too, it is a prolific issue, whether or not it's locks or afros or other sorts of hairstyles.
I don't understand how the Court of Appeal got that to say that other schools did not have similar school grooming policies to that degree.
Quite widespread, and I'm shocked. I was shocked to see that reasoning, and I disagree with the Court of Appeal that this does not affect the right to education strongly on that.
And I also take the view that governments, when it comes to basic fundamental rights and freedom, we must take a decision that says, whether publicly funded or private, every workplace, every educational institutions must comply or you are in breach. I think we have this third level approach to how our rights are asserted or our rights are upheld. And I think we must get away. What's the point of the charter if it is that I'm going to be navigating a concept, a principle that I can go and I'm going to be reaching out to school A in this location to send my child, and then school A say, no, you can't come here because I have a similar rule. Then I go to school B, C, D, and so on. Every institution, and I go a step further than others, our colleagues, attorneys, and so on, human rights advocate, that is not just a publicly funded institution. We should ensure that every single workplace, every educational institution, if you violate my fundamental rights and freedom, you would be in breach. You would have discriminated against me.
Yes.
And I think we have to get to that approach wherein we know that our rights, as they are established in the Charter, mean something.
You know, as you spoke about the cost and the process that the Virgos had to go through, and I consider that now that the matter is over, we will all benefit as a society from what the judgment would have handed down.
Yeah.
And that they had to go through this on their own, that this was not a free process, that this was not an easily accessible process. Is a concern. I know that we have had the robust advocacy on a national human rights institution, for example. And I think when we look at the cost of things like this is some of the gaps that an NHRI would fill.
Yeah. All right. I want us to pick up on that point, Jade, because the government, by way of the Attorney General, fought this every step of the way. I want us to pick up on what that means and what the Ministry of Education needs to be doing differently going forward. But we take the break and then we finish out the discussion.
I stay locked into Olympics because, of course, I'm Jamaican.
I tune into the Olympics, but I'm always busy. What I have to know when Sharika Jackson beat Shakari.
She's storming to victory here. Watch the clock. This is so fast.
Brother, I have to see every notification for the Olympics. Me, who want to hear every run.
The Jamaican's coming. He's closing. What a performance.
Every jump and every fling.
Oh, wow.
Live. Nothing can miss me.
We're always on the move.
So while I'm driving,
Thompson here from 60 odd, moving away, and she gets the victory.
she's jogging, or at work,
Hurry, the race is about to start.
we can't miss a beat.
Oh, me?
Because we keep it locked.
To the only station for the Paris Olympics.
Nationwide.
90 FM.
Parents, gearing up for back-to-school expenses? Well, Chris and Charles is making back-to-school as easy as ABC. From July 1st to August 23rd, 2024, borrow at low rates, and hear this! You could win one of 24 back-to-school grants of $50,000! Imagine the possibilities, covering all your expenses and winning big! Call us at 876-926-0609 or visit our website for details. Conditions apply. When you think loans, think Chris and Charles. Authorized on Section 58, Betty Gaming Lottery. Ready, set, go!
Where am I, the winning spirit? The winning spirit. Jamaican spirit. Where am I, the winning spirit?
Time for unite as one. Everybody go grab your rear rum. Support we at least them on number one. Shine bright like Jamaican sun.
Where am I, the winning spirit? The winning spirit. Jamaican spirit. Where am I, the winning spirit?
Must be 18 years old. Listen, drink responsibly.
Welcome back to Let's Start Justice. We are wrapping up the discussion on the Virgo case, the Kensington case that was handed down last week. And a few thoughts. Some of us are anti-Caribbean Court of Justice, CCJ. But the basis upon which the freedom of expression was reversed and asserted by the Court of Appeal is the McEwen case coming out of Guyana. And I can't say this enough, that the CCJ is beyond cost implications. That's a critical underpinning, because the more of us that can go to the Caribbean Court of Justice, it means that, importantly now, we're developing what we call jurisprudence. We're developing decisions that will be used as the basis to examining future cases. So this particular case that came out of Guyana, that was deliberated and handed down by the current president of the CCJ, Justice Saunders, it is spelt out in this Kensington judgment. So the CCJ is an important institution for developing the body of case law that we can use in terms of how we're going to be interpreting our charter, our constitution, the rights and freedoms that we have that were enhanced in 2011. Yeah? The other thought on this particular matter, the Charter of Rights and Freedom, it was revised in 2011. No administration since then saw it fit to ensure that how we are looking at some of these constitutional rights is so broad that a family would not be subjecting themselves to be getting attorneys to fighting a matter in court. Not one of the political parties should be celebrating anything. Not one of them. I take it a step further, that when the family raised this matter to the school, an assertive, proactive, and rights-based Ministry of Education would have come to a reasonable position to begin with. You would not have a school grooming policy that is so vague that schools can run rogue in how they interpret, and then we come with this concept of rules are rules. A rights-based and assertive Ministry of Education would not have had this matter going before the Supreme Court. A rights-based and assertive government would not have the Attorney General's office fighting every step of the way, upholding these offensive policies that says that, guess what? A child's right to education had not been breached. A child's freedom of expression had not been breached because somehow the natural hair carries fungal infections. I want you to think on these things, you know. The government fought it every step of the way, wasting taxpayers' money and subjecting a child to something that was unnecessary. And let us say this, constitutional challenges are important because you want to look at how the courts interpret the law. That's the real reason for the judiciary as well, that independent branch. We're going to be challenging things. We're going to be having different concept of what they mean, and the courts come to a definitive stance on it. However, reasonableness is important from the different state authorities and bodies, where it would not have taken a family what I would call an unnecessary position to take had the Ministry of Education acted in a manner at the cabinet made a decision that was in keeping with the Constitution. It needed not to have gone to court, in my humble opinion. Yeah?
Yeah.
Now, having said all of that, I hope, and I saw the minister on different media interviews saying that the case is critical in how they're going to be interpreting the school grooming policies going forward. And I say to the minister, with the greatest of respect, that it is now important and incumbent on the ministry to go through its own school grooming policies and set something that is a little bit more prescriptive. Stop turning the school administrations into attorneys. You don't need to be circulating that judgment. Have a session on Zoom, a little webinar, so that we can challenge the colonial ways of thinking. Get a sense of why the schools may be coming up with some of these policies. Revisit your education's regulations and again ensure that you take a proactive approach and set more prescriptive guidelines that schools must follow. They're not laws unto themselves. They must act, and we must always start from the Constitution in this country. Now, I see some comments in the chat on a separate matter, yes. Jade. So often we get complaints, even from relatives, that say that I have a sister, an aunt, a family member, that I think that person is not respecting their child, not protecting their child. And I think a child may have been sexually assaulted or so on. And we would have... We're up on the break? No? No. And I think that the child was sexually assaulted and we would have referred that child, for example, to the CPFSA, the Child Protection and Family Services Agency. Now, this particular matter that a mother allegedly knew her child to be in the company, I think the child was what, 11?
Yes.
11 years old, to be in the company of a 23-year-old man, big man. And the mother had that child knowingly, apparently, to be having sex with that adult. You can correct me if my recollection is wrong.
No.
And the matter went before the court. The mother was apparently investigated and possibly was charged, I believe, or
Yes.
looking to be charged with negligence.
Right.
What happened with the rest of that case?
So it was essentially discharged. Was found that she was not liable.
For her child being missing for days?
Yes. I didn't actually see, I saw the reporting, but I didn't see exactly what the court said.
Mm-hmm.
So I don't want to speak onto the reasoning.
Of the court, yes.
Yes, but just on the facts, it does
Alone.
seem a strange decision to have come to. Yes.
Yeah, and again, in keeping with Jade's comment, it raised my eyebrows a little bit. And I just saw it in, I think it was the Observer. I saw the coverage. But it's something that we're going to be looking at because we have a view here that parents must accept responsibility for their children beyond the legality of it. You know, the Child Care and Protection Act is clear, but when you have minors, the burden of responsibility must be on parents to know where your child is at all times. And far too often we see instances wherein it would suggest, and I'm not speaking on this particular matter here,
yes,
that the family know that their children are out having sexual relations, and it seems to be a transactional arrangement that would have happened. So I'm going to be looking at the court's reasoning, but it raised an eyebrow, and I think if the Child Care and Protection Act, by the way, it's years we've been calling for that particular legislation to be reviewed, because while you do not want to criminalize poverty in some instances, I think we must hold parents responsible when children are violated, and they should have acted in a reasonable manner to protect that child.
Yes.
A coverage, I remember a couple months ago, a 16-year-old, I saw the article, the child working, that child was killed, I believe, working and so on, had multiple partners. And it wasn't until I got to the end of the article, I kept asking myself, how old is this person? Because that child seemed to have lived an entire lifetime, 16 years old. So we can't speak on the specific case here, but it does raise an eyebrow. And I think we have to ask ourselves, how much do we hold our parents accountable? Where the gaps are in law, and we have to ensure that we uphold the law, strengthen them, and offer greater protection for our children. They're our most vulnerable. And I must say to the Minister of Education again, the Child Care and Protection Act needs comprehensive review beyond mandatory minimums for murder. Yeah? These are the things that we should be reviewing.
And it was promised in the 2018 report as well.
2018, I think it was promised in 2018.
That's my most recent
You need
reference.
to look how many years before it was promised, but we keep on doing this piecemeal thing, and then we come and act outraged. Outraged, you know. Let's hold our parliamentarians accountable, because any one of them in parliament, all 83, I say 83 because remember you have one seat vacant down by Trelawney there.
Yes.
But 83 of them in the lower and the upper house, any one of them can introduce a private member's motion if the Ministry of Education isn't doing it, rather than going on social media and acting outrage. We must hold them accountable. Yeah.
So before we close the show, we do have a winner for our trivia question. Our trivia question was, where in the Constitution, Section 13, do you find the right to freedom of expression? It is found in Section 13(3)(c), but the person who responded is Justin.
Oh, Justin, the young one again.
Yes. But Justin went a step further to let us know that it is usually read with Section 13(3)(d) as well, which speaks to the right to seek and disseminate information.
Yes.
So you were correct, Justin. Thank you so much for participating, and we will reach out to you via WhatsApp with your prize.
All right, thank you so much. Have a good week. We appreciate those who listen, those on the NNN YouTube, those on the JFJ YouTube platform. Have a good week. My name is Michael Jackson.
And I'm Jade Williams.
Jamaicans, by justice, the people's champion. Justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
JP said Mary's banana chips. 20% more chips in the banana left them crumbs. The time by JP said Mary's banana chips is
2:00.
The highly anticipated event for innovators and business leaders is back. That's right. The Realign Business and Investment Conference is set for July 23, 2024 at the AC Hotel in Kingston. Tune in to Cliff Hughes Online on Nationwide 90 FM from 10 a.m. to 1 p.m. as we help them to highlight this year's theme,